My lords, I now turn to the text of the treaties and enacting legislation and to the SIA. And this is an exercise which, with the court's assistance, I intend to carry out relatively briskly. If we start, please, with the New York Convention, which you will find at bundle A7, tab 97. You have Article 3 at page 3341. So tab 97, page 3341. In tab 7.
You've got it.
Yeah. Your attention has been drawn to the one distinction, the one difference rather, between Article 3 and Article 54.1, which is the words in accordance with the rules of procedure, and I draw your attention to the following, of the territory where the award is relied upon. So what we're talking about here is rules of domestic procedure, and I'll come to that in a second, because that's the only distinction that is being drawn. Article 5 will be familiar to you as setting out the grounds for challenge, and Article 6, if you would remind yourself, are the provisions about security which were at issue in IPCO. Now, on this question of domestic procedure under Article 3, may I please draw your attention to general dynamics, which is A4, tab 50, page 1994. Maybe you don't need to turn it up. What I will do is I'll just read it to you in the interest of time. And this is a Supreme Court judgment.
This is general dynamics, yeah?
General dynamics in the Supreme Court.
Sorry.
So I'll give you A4,
Yeah, I'd quite like to look
tab 50. Page 1994 of the judgment. And this is in the judgment of Lord Stevens, who, I make it plain, my lords, he was in the minority, but I respectfully, it doesn't matter at all on the point I'm going to show you.
Yeah, I remember this case because I was in the Court of Appeal then. So.
Right.
Yes.
And we rely on this, by the way, my lord, because I will come back to it. We rely on this also with respect to all the points on the CPR.
Right.
Because what this Supreme Court judgment is authority for is that the procedural tail cannot walk the substantive dog. Either the 1966 Act does its work on its own, or rules of court cannot save it. And obviously it doesn't do the work. Anyway, paragraph 242. There are exceptions to the common law principle of access to justice, but none of those exceptions apply in this case, which is concerned with procedural rules enabling access to a court rather than the substantive rules for determining, for instance, whether there is state immunity. So state immunity as a matter of English law, as a matter of public international law, yes, it's procedural, but not as a matter of English law. So what Article 3 is referring to are the rules that are implementing how a judgment, etc., are to be is to be obtained, and that you find, if we could then move to part 3 of the Arbitration Act 1996, which you will find in your supplemental bundle at tab 167. Tab 167 of the new authorities, the Arbitration Act.
The substantive procedural issue has been considered in a number of cases, including in Benkabush, and also in relation to the Act of State Rule.
Yeah. So the rule is clear that as a matter of public international law, it is procedural, leading, for example, in front of the International Court of Justice. As a matter of English law, as you see from the passage that was quoted to you, it is a substantive rule. There's nothing procedural about it. Just test it. I mean, if you look at Article 3, this is quite clearly not referring to rules of state immunity. It's referring to the rules applicable to transpose the award into, which we're going to look at now. So part 3 of the Act, you've got section 100, which defines New York Convention awards. You've got section 101(2), which I wanted to draw to your attention because that says in terms that a New York Convention award may, by leave of the court, be enforced in the same manner as a judgment or order of the court, to the same effect. So, and the reason why you have the need for the leave of the court is because, of course, you've got the Article 5 grounds, which are relevant to the standards of review, but not to state immunity. Then you've got sections 103(1) to 4, which enact Articles 3 and 5 into English law. So Article 3 of the New York Convention is in fact transposed.
Sorry, which paragraph's that?
So 103(1) to 4. You see, this is transposing rather, the scheme of Articles 3 and 5 into English law. And that's the legislative technique, obviously, to convert or to transpose an obligation which is only binding on the UK at international law level into domestic law. Section 103(5) enacts Article 6. Now, if we turn, please, to the ICSID Convention, which your lordships have been referring to in volume A1, so I shall do the same. A1-2 at page 28.
Yeah.
Starting with the preamble. It's very important to note that agreement on the text of a preamble is itself generally quite hard fought. So all sorts of statements can be made, for example, by various negotiators during the travaux. But ultimately, there is a very careful balance that is reached in the preamble. And it is my submission, and I will develop that a bit when we come to the principles of interpretation, that the only place where you can find object and purpose is here. And I will show you that what is being done is that a mix and match of travaux and even extraneous material is being cobbled together to give you a purpose for the convention, which is not the purpose of the convention. Now, the contracting states, considering the need for international cooperation for economic development and the role of private international investment therein, very careful and balanced wording. With respectfully submit, there's nothing pro-investor in here. Bearing in mind the possibility that from time to time, disputes may arise in connection with such investment between contracting states and nationals of other contracting states. Again, you can well see that this is the result of a diplomatic exercise, and again, balanced and not pro-investor. Recognizing that, again, the balance, while such disputes would usually be subject to national legal processes, international methods of settlement may be appropriate in certain cases. You've got a conference of negotiating parties which has developed countries and developing countries. You find balance in the preamble, not pro-investor stance. And then you get to bits that are actually getting more important, attaching particular importance to the availability of facilities for international conciliation or arbitration to which contracting states and nationals of other contracting states may submit such disputes if they so desire. Strong emphasis on consent. Desiring to establish such facilities under the auspices of the International Bank for the IBRD, recognizing, again, another preamble dedicated to that, that mutual consent by the parties who submit such a dispute to conciliation to arbitration through such facilities constitutes a binding agreement. One might say that's a tautology, which requires in particular that due consideration, again, look at the wording, that due consideration be given to any recommendation of conciliators and that any arbitral award be complied with where there has been mutual consent. And then declaring that no contracting state shall, by the mere fact of its ratification, acceptance, or approval of this convention, and without its consent, be deemed to be under any obligation to submit any particular dispute to conciliation or arbitration. And we say, my lord, that yes, absolutely, the object and purpose of this treaty is to create a facility which states may or may not use. It is not to mitigate sovereign risk. Terribly sorry, but it just isn't. It may have that effect if states choose to use it. And think about it. I'm sorry, but I've seen it in practice, but think about it. You've got states that have very different perspectives. You need to find that balance. And you need to tell them, don't worry, we'll put in the convention what is there. Then you decide if you want to ratify, you decide if you ratify would just be optional. You can well imagine Mr. Brokers working the room doing exactly that. And this is based on consent. And you will have Professor Schroer telling you time and again in his commentary that the cornerstone, his words, of the convention is consent. And that is all you get from the only thing you're entitled to look at for object and purpose. Not mitigation of sovereign risk, not please help the poor investors. This is what it is. We are creating a facility. You may use it if you wish. You will only use it if you consent.
Are they necessarily quite inconsistent? I mean, it may be that they're creating a facility that allows people to mitigate sovereign risk.
It may well be, my lord, but again, what you need to do is to for interpreting the treaty, because what we submit is happening is that because there is this need for an implication, I have shown you there is no inevitability, is that focus is being put to one of the effects of what is truly the purpose. There's a reason why purpose is so narrow, because this is all negotiated. And then that purpose is being used in order to do exactly what you're not allowed to do, which is teleological interpretation. So that's what we say about the preamble. Now let me take you to the provision, which I'm sorry to say my learned friend was rather skipping over, which is the cornerstone of the convention. Article 25. Article 25 is at page 33 to 34. It starts at page 33. And even when, I'm sorry, I won't take forensic points, but there was even some reluctance to read the words consent in writing. This convention can only ever be binding on the state if, in the words of Article 25(1), the parties to the disputes have consented in writing to submit to the centre. If not, the convention is foreign to them. Ratification of the convention, as you've seen from the preamble, is not binding them, is not creating anything at all. Nor, and let me make that point straight away, nor is the BIT. What does the BIT do? It's simply creating an offer to arbitrate. What you then need to have is an acceptance of that offer, and this is where consent allegedly arises. That's where all the jurisdictional points arise at the time of creation of the arbitration agreement through acceptance of the offer in the BIT. The convention thus simply creates a framework for arbitration. It does not create arbitral jurisdiction. Jurisdiction must arise from a separate agreement to arbitrate. By entering into the convention, a state simply gives itself the option to use it. It may choose to do so for certain disputes or not at all. That separate agreement could be in a contract. There are many such cases, or as is alleged in the present case, by way of acceptance of an offer contained in a BIT. So while a state must become a party to the convention in order to get the option to use it, acceding to the convention does not make the convention automatically applicable to any dispute. To make the convention applicable to a dispute, the state in question must enter into a separate arbitration agreement, which will have its own terms, and in the words of Article 25, I quote, consent in writing to submit that dispute to the centre. And in that sense, this is no different from what commercial arbitration rules, like the LCIA rules or ICC rules do. They will apply where there is an agreement to arbitrate under them. If there is no such agreement to arbitrate, they have no application to the parties' disputes at all. They are foreign to them. So for my learned friend to now say that entering into the ICSID convention and all the BIT gives him an independent source of jurisdiction is, with respect, entirely misconceived. You can only get there if you ignore Article 25. Contracting states only ever agree to apply the convention to disputes which they would expressly consent to arbitrate under the convention. And the convention is not engaged at all unless there's a valid agreement to arbitrate. Article 27, my lords, I'll just show you because this is the one about diplomatic protections. And you see 27.1, and that is really truly important. I mean, if you want to find purposes for the convention, that really was beyond the preamble, the purpose. Depoliticize investment disputes. And that is Article 27.1. And I do say that was the remedy which was going to bite non-compliant states. And it is said against me that, well, while it's true, that's why the Article 54.1 language was inserted, the language is neutral. It applies both ways. It's not the only reason. But my lord, it was the main reason. And the Travaux shows that it was the main reason. And you cannot ignore that. In fact, when you look at Pinochet and Lord Gore's speech, he does exactly the same thing. He says, yes, it wasn't the main reason, but there were other reasons, but the main reason was and then he goes on to say what he says in the speech. So it is a relevant, certainly a relevant factor. As I've shown you, Article 54.1 works as drafted, and there is no basis to imply a term creating a submission and doing away sub silentio with states' immunity from adjudication. There is no necessity or inevitability. I'm sorry, here I'm repeating myself, but let me make a new point. It's now being said, and I do say that's not in the preamble, and I do say this is all teleological, but it's being said, oh, this would have been very important for investors. Investors need this. But also, this is an ex post facto construction. You will not find that theological point anywhere in the Travaux. It's not supported by the Travaux. And I would ask you to pause here for a second. This also makes no sense. Because what is being said is it was very important for them to get conversion into a state judgment, which they could then not execute because there was absolute immunity from enforcement. Just say with this jurisdiction, very, very important. The UK must comply with its obligations and give the investor a judgment which it will never, ever be able to enforce because Article 55 is absolutely clear that there can be no immunity from execution. Respectfully submit, my lord, this is all an ex post facto construction. The reality is that you had civil law countries, you had common law countries. The civil law countries tend to not look at adjudicative immunity. They go straight at the level of immunity from execution. We do, and nothing in the convention has done away with it. Now, the next provision I wanted to look at is Article 41, which has the tribunal shall be the judge of its own competence. There's nothing magical at all about that provision. One finds the same provision for competence in every single set of commercial arbitral rules. Indeed, you find it in Section 30 of the Arbitration Act 1996. As explained by Lord Mensin Dalla, that does not close any arbitral tribunal with final jurisdiction to determine its own jurisdiction. An ICSID tribunal, my lords, is an arbitral tribunal. It only exists as a creature of the parties' consent. It cannot pull itself by its own bootstraps. So when you get to Article 52, which you find on page 40, that doesn't take you any further. Because that gives what? A second-tier tribunal, itself a creature of the convention, itself entirely dependent on whether there was consent to apply the convention in the first place, the power to review the award of the first-tier tribunal. It doesn't expressly refer to jurisdiction, but it is well established, and we accept that it is one of the grounds on which the award can be annulled. But when it comes to issue estoppel, if that's supposed to create an issue estoppel, I draw your attention to the fact that the test is not de novo review, as under Section 9, but manifest error. Remember that internalization says nothing about state immunity. What are internalized are the grounds for review or challenge that are normally left to an enforcement court under Article 5 of the New York Convention. And as we shall see in a moment from Tatneft, the question of arbitral jurisdiction under the SIA sits outside that regime. It arises entirely independently from the grounds of challenge, whether under Article 5 of the New York Convention or whatever they are, and there are none, fine, under the ICSID Convention. But it's an entirely separate issue. It's a statutory obligation which the English courts have to satisfy in order to affirm their curial jurisdiction. It's also important to note in that respect, again, what an ad hoc annulment committee is. It is not a separate judicial entity sitting outside the convention which might have its original jurisdiction, as say the International Court of Justice might. It is itself a creature of the convention. It is, as I've already put it, a second-tier tribunal. If the convention does not in fact apply, it cannot create or confer jurisdiction when none exists. I won't spend time on Article 53, although it's obviously important, but your lordships have seen it. Article 54 is the focus of our inquiry. I've already drawn your lordship's attention to the identity of wording between it and Article 3 of the New York Convention, and the one difference, and neither provision says anything about state immunity, which falls to be analyzed under the provisions of the SIA. Now, let me say one thing about Article 55. Article 55 was introduced in the wake of Article 54.3. Why? Because once they introduced a mechanism referring to domestic law on the basis of the Treaty of Rome, Article 192, so that's 54.3 and not 54.1, they said, well, you know, now we are actually dealing with domestic law, we'd better make it plain that here also, I do say here also, we are not waiving state immunity. And it's very, very clear. Everyone has always accepted this is for the avoidance of doubt. This is Mikula, paragraph 72, in terms. And now it's being said that you use a provision that is clearly on its terms being introduced for avoidance of doubt to infer, implication, a contrario, that you waived state immunity from adjudication. Well, that's turning the law on its head. If state immunity is to be waived, it must be done expressly, not in that sort of roundabout way. But anyway, then moving on to the implementing legislation, which is the 1966 Act, which you find just before the convention. Section 1.1, second paragraph. That convention is in this act called the convention, and its text is set out in the schedule to this act. Could you please compare, say, section 4, at page 24. Status, immunities, and privileges conferred by the convention. In section 6 of chapter 1 of the convention, which governs the status, immunities, and privileges of the ICSID, articles 18 to 20, 21A, and Article 24 shall have the force of law. In other words, that is the extent of the transposition. Appending a convention as a schedule to an act of parliament doesn't give it the force of law in the UK. Look, I simply draw your attention insofar as you're still wanting to rely on Mr. Justice Fraser's judgment. I think by now you're going to have to make up your own minds. But that his lordship at paragraphs 95 and 102 says, oh, the convention is a schedule to the act. So, the only provisions of the ICSID Convention that have the force of law in the UK are Articles 18 to 20, 21A, 23.1, and 24, and they relate to status, I emphasize the word immunities, and privileges of the censor. The rest of the convention, being a schedule, doesn't give it the force of law in the UK, and the fact that the 1966 Act must be construed in a way which gives effect to the UK's international obligations takes one no further. Actually, we say it's important and works against the argument being made against us that Article 53 to 55 were not deliberately not transposed into UK law, whereas other provisions dealing with immunity were. If these were the provisions that were doing away with state immunity, which is an obligation that we have under customary international law to all other states of the world, obviously they would have been transposed. It was never intended to do that. Now, sections 1.2 and 2.1 are the equivalent of section 101 of the Arbitration Act 1996 for New York Convention Awards, with the difference we've already all very aware of, which is that there are internalization of grounds of review, therefore you don't have the Article 5 grounds. Again, that says nothing about the rules of state immunity. And section 2.2 was the one considered in Mikula. Now, if we could turn now, please, to the State Immunity Act, which you find in the same bundle at tab 4. Lord Chancellor, perhaps if you let me know if I may proceed or
Right.
when you're ready.
Yes.
State Immunity Act. We've got the rule in 1.1 that the state is immune from the jurisdiction of the Court of the United Kingdom, except as provided in the following provisions of this part of this Act. So couldn't be clearer. Section 9 deals with arbitration. And of course there's section 2.2, but you're aware of it. I just wanted to focus on 9 now, which is that where a state has agreed in writing to submit a dispute which has arisen or may arise to arbitration, the state is not immune. And the where in that sentence clearly means if. And so I won't take you to that net, my learned friend has, but I wanted to bring out a couple of further points, if I may. So perhaps just for your note. At paragraph 30, unless you want to see it, my lord.
Can I just raise this
Yes.
point? Because one of the things I've been puzzled by is that the in the award, the tribunal found that your clients had consented in writing to the arbitration through the agreement of the bit between Switzerland and Zimbabwe. That's what they found. So
Yes, my lord. So the way this works is that, and you have that very regularly in jurisdictional arguments under BITs, which, for example, if it's an uncitral arbitration, the BIT will then be, for example, challenged at the seat, or there will be enforcement proceedings on the award. The questions that arise is whether the specific conditions for example, qualifying investors, qualifying investments, territorial scope of the treaty are fulfilled. And that's exactly the sort of point that is going to be raised on the challenges that Zimbabwe will bring. To give you a bit of flavour.
but are those not issues as to issues as to the scope of the reference to arbitration, as opposed to in relation to which the convention at least contemplates that that's a matter for the tribunal rather than the court? I'm simply dealing with the prior point, which is whether your clients consented to submit to arbitration. It's their dispute with these investors. And what the tribunal has found is that you did through entering into the bit.
Yep. No, my lord, with respect. It says the acceptance of the investors of the offer contained in the bid creates the arbitration agreement. That's Occidental and Ecuador. I mean, there's a lot of law on this. And that will only work if, in fact, for example, in this particular case, the claimants were not of the nationality of the of Zimbabwe. And there will be other conditions like that. So these are the jurisdictional points which will go as to whether there was consent to arbitrate. So Zimbabwe makes an offer to arbitrate. It makes that offer on specific terms. And so in nearly every investment arbitration, which one argues or one sits on, you will have jurisdictional points about, is this investment covered? Is this investor a covered investor? Etc., etc. So this is the sort of point we're talking about.
Yeah, I mean, what the tribunal found in paragraph 199 is based on the foregoing provisions. That was Article 10 of the bit. In the case of these investors, it is equally clear the respondent, that's your client, has consented through the bits, provided the relevant criteria are satisfied. And then they discuss the tribunal so finds the relevant criteria discussed below. They then discuss the relevant criteria and then reach a conclusion that they are satisfied. And that's the way in which it works, isn't it?
Yes, my lord. And if they are wrong, then there was no consent. And then there's no, ICSID is not engaged at all. And that is precisely the inquiry under Section 9. Again, this is all being portrayed as something very difficult and not normal. It is absolutely normal that you would check consent to arbitrate in order to take curial jurisdiction over a foreign state. And the tribunal, of course, will reach a finding. We all reach findings when we sit as arbitrators. We cannot clothe ourselves with jurisdiction. Whether we make a finding of consent, of course we do. But then, is that finding correct or not? And that is then tested by the curial court or under Section 9. You cannot, and that's Tala, it's bootstrapping. You cannot clothe yourself with jurisdiction.
It's odd though, isn't it, that there is no, under the 1966 Act procedure, there is no equivalent to either Section 67 of the 1996 Act or Section 101(3) of the 1996 Act.
My lord, no, with respect, no, it's not odd. It's a feature of the ICSID system. So it's important to understand that feature, but it's also important to understand its limits. Why do you not have a Section 67? Because ICSID arbitrations have no seat. Fine. Why do you not have the equivalent of Article 5 or Section 101? Because ICSID arbitrations have internalized avenues of challenge. As Mr. Brockes said, a difference of degree, not of kind. Section 9 of the State Immunity Act sits outside all of this. And while you can't reopen the award on substantive merits grounds, Article 5 grounds, what you do need to satisfy in order to get the curial court, in order for the English court to take jurisdiction over a foreign state, is consent to arbitrate.
So can I say this? If a state did not take a state immunity point, waived state immunity, but did wish to say there's no jurisdiction, they couldn't do that. Can't.
Because it has taken a step in the proceedings of Section 238. That's exactly what happened in 23B. Exactly what happened in Mikula. Oh, this is all being portrayed as, completely outrageous. It's perfectly normal.
Why do you say they've taken a step in the proceedings?
Say again.
Why do you say they've taken a step in the proceedings?
Because they don't raise immunity, and then they go and, for example, say, grant me a stay. So they're raising merits points.
Well, that's what I'm trying to understand. I mean, your clients took issue with whether or not the tribunal had jurisdiction.
Yes.
And they fought that battle and lost it. But they then participated in the arbitration, albeit under protest, presumably, and called witnesses and so on and so forth. But they never took the state immunity point, did they?
My lord, state immunity is not an issue taken in front of a tribunal. State immunity is something which arises in the English courts. It's about this court's curial jurisdiction.
Well, I know, but I'm saying they didn't take an issue of state immunity in Zimbabwe, of state immunity as the state of Zimbabwe.
Where, my lord? I'm sorry, I'm not following.
Well, I'm just wondering.
It would not take such a point in the arbitration. State immunity is not an arbitral jurisdiction issue.
I understand that,
Yes.
but I just wondered, normally if somebody's going to take an issue of state immunity at some point, it's flagged up.
My lord, with respect, no, because we can't predict while fighting the arbitration. I wasn't there, but whoever was fighting the arbitration can't predict where it's going to be enforced. I'm not going to say if one day you decide to enforce in the United Kingdom, we're not submitting to the court of the United Kingdom.
No,
That goes without saying. It's a rule of custom international law.
Okay.
My Lord Tatneft,
Yes, where's that?
paragraph, so I won't take you to it because I do need to get through quite a bit still. But it is a very important decision. We do say, my learned friend, too quickly to it.
Where is
please.
it, Tafnet?
Okay, so it's A3, tab 43,
Yeah.
page 1614.
I didn't hear the page on that, I'm sorry.
1614. If you pick it up at 1618, paragraph 17, see that Ukraine raised objections to the tribunal's jurisdictions under the BIT, which were subject of written submissions, and those were dismissed. And then at paragraph 30, you can see that the objection to the state making its case on section 9 in that case was that 1, the section 9 objection was that the tribunal had no jurisdiction, and 2, in effect, it was being said Ukraine should be confined to the jurisdictional case that it had run before the tribunal. It said you cannot take new points, right? So implicit in that, obviously, is that all of the points that were run could be run again. At paragraph 31, Mr. Justice Butcher describes how the arguments being run by Ukraine on section 9 were a mix of points that were new and points that had been raised in one form or another before the tribunal. And the key paragraph is 35. And the key finding is that letter D. Sorry, I should draw your attention, in paragraph 34 to the fact that he says, the judge, at H, there is nothing in the SIA which in any way resembles section 73 of the Arbitration Act or otherwise suggests a similar philosophy. And then at 35, at D, he says, if there is an issue which is either apparent to the court of its own motion or is raised by the state, and which goes to the question of whether there was such an agreement in writing in relation to the relevant dispute, then I consider that the court is obliged to consider it and can only exercise jurisdiction over the state if satisfied that the section 9 exception is nevertheless applicable. There is nothing in the SIA which suggests that there can be a foreclosure of the points which the state may raise as to the applicability of the immunity afforded by the SIA by reason of what may have occurred in front of an arbitral tribunal in a way similar to that provided for by the Arbitration Act, i.e. section 73 doesn't apply, you cannot have foreclosure. So, my lords, the court must decide the issue of arbitral jurisdiction for itself. Because this concerns your jurisdiction, your curial jurisdiction, and you're mandated to do that by the SIA. That is a point which is entirely separate from any review of the merits, of jurisdiction, of anything at all under sections 101, 103, Article 5 of the New York Convention. And that is why section 73 does not apply of the Arbitration Act. And the fact that those grounds are internalized under the ICSID regime to a second-tier tribunal is neither here nor there. Section 9 applies just as much to an award under the ICSID Convention as it does to an award under the New York Convention. By its express terms, it requires the English court to determine whether there was arbitral jurisdiction in order to assert its own curial jurisdiction. Well, that is the scheme of the SIA with regard to arbitration. And that is what is applied day in, day out in the commercial court. Another example in the bundles, I will take you to it, Gold Reserve, A3, tab 37, page 1233, paragraphs 11 to 12, which is page 1237. So Gold Reserve, exactly the same. We do this in the commercial court day in, day out. And the investors, with respect, are now inviting you to drive a coach and horses through this well-established scheme by holding that Article 54.1 of the ICSID Convention, and it will follow Article 3 of the New York Convention, constitute waivers of jurisdiction under Section 2.2. Now, that attempt to circumvent Section 9 of the SIA by means of Section 2 is misconceived for two reasons. First, Because Article 54.1 does not in fact contain a submission to the jurisdiction. Secondly, because it is contrary to the scheme of the SIA. Let me cover the point about the scheme of the SIA first. But very briefly, to come back to the question that was being asked by my Lord Justice Phillips before lunch, must make it clear it is common ground, as I understand it, in this appeal, that whether you call it waiver, whether you call it submission, and I completely understand, my Lord, why you are using the concept of submission.
Yeah.
That is the concept in section 2. It has to be consistent with the UK's customary international law obligation, and you've got case after case from Pinochet to Benkambush. I will just give you the reference in Sokis, which is A451 at pages 2009 and 2029, paragraphs 43 and paragraphs 115, very clear that you cannot have an implied waiver. You cannot have an implied submission. You must have an express submission.
Sorry, I didn't catch the reference.
My Lord, Circus,
Yes.
volume A4, tab 51,
Yeah.
paragraphs 43 and 115,
Yeah.
which you will find at pages 2009 and 2029. Now, let's look at the scheme of the SIA. My Lord, you will forgive me for not spending any time at all on ISS ground 1. It is with respect completely misconceived based on the simple and clear wording of section 1.1 of the SIA. The SIA is a complete code. It is not, and I quote, a complete code with one outlier, as my learned friend for ISL put it on Tuesday, and that is transcript, day 2, page 162, lines 15 to 18.
Yeah.
If Article 54 is a submission, so is Article 3 of the New York Convention. And as I was saying earlier, my lords, the amendment moved by the Solicitor General had no raison d'être. Virtually all foreign awards, ICSID and New York Convention, were already being caught under Section 2. It's just that none of us had noticed. So Hansard, if we may please look at that, is at A7, 121, tab 121. And it is page 3856.
So 121.
A7, 121,
Yeah.
3856.
Yeah.
Let's start by bearing in mind again that if the Solicitor General had wanted to exclude the 1966 Act and ICSID awards from the SIA, it had the simplest way to do it in the world, which was simply to add the 66 Act to the list of excluded legislation under Section 16. Instead, he moves an amendment which is meant to ensure that the arbitration exception will apply to foreign awards. And he says, and that will include ICSID awards. We respectfully submit that this is, if there's any ambiguity, this makes it plain as day that Section 9 was the route that was being chosen for the enforcement of ICSID awards. And that makes perfect sense because irrespective of the type of award, ICSID or New York Convention, the cardinal principle is consent to arbitration. Professor Schroyer, the cornerstone of the ICSID Convention. And matters do not stop there, my lord. Section 23.3 is relevant, but in a way which I'm not sure has been appreciated on the other side. If we can please go back to that, and I'm sorry I'm making you move between bundles, but if you go back to volume A1 at tab 4, the State Immunity Act.
Well, I wouldn't take up
Hello.
too much time on section 23.3 if I were you.
No, it's a completely different point.
Because it just, well, speaking for myself, I can't see how
No.
the point even begins to run. the matters referred to
I couldn't agree more.
don't seem to me to include a statute made 2 years previously.
The question, my lord, is ask yourself why they are contrived to run this point. They contrived to run this point because they need to find a way of telling you, oh, no, 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 the 1966 Act, even though it doesn't say so at all, abrogated common law state immunity. By the way, not a point that was run by my learned friend in this appeal below, but now he's jumped on that bandwagon. So because you've got that, then you need to find an exclusion, but it's not in section 16, so you make up this section 23. The whole thing crumbles, we respectfully submit.
Well, if you're wrong about section 2,
Yes,
then that's all irrelevant because they get home, as it were, on section 2. If you're right about section 2, which is what you've been addressing on, then they will be dependent on section 9.
indeed, my lord. And so I'm
Simple as
just,
that.
if I may, what I'm doing now is just
23.3 won't help.
23.3 will help, if I may show you, in a
Well, it
very,
will help
in a
now.
very different way. In a very different way.
Yeah.
And I will show you that now. So what I'm doing, to be clear, at this point in time in my submissions, is killing off section 2. I respectfully submit, it's clear as day, including from Hansard, that the route chosen was section 9. But let's look at what the consequences would be if it were section 2. And you find that in 23.3. And there's the two bits which haven't been looked at, which are the two examples, my lords, which is that under section 23.3a, if you're under submission, section 2.2, the Act will be disapplied for any prior agreement, right? Which will be the treaty in this instance. Or rather, the time when the particular state entered into the treaty. Whereas under 3b, under section 9, it will be the time when the agreement to arbitrate is concluded. So what does that do, my lord? If the correct analysis is, as we say, consent to arbitration and section 9, the SIA will apply every time, now that we are 40 years later, as the agreement to arbitrate will be formed by the investor's acceptance of an offer to arbitrate in an investment treaty. That's 23.3b. But if you're under section 2, then the legislator would have put in place we submit completely incoherent regime, whereby if the respondent state acceded to the ICSID convention before 1978, so the agreement here under section 2 is pre-1978, you got the common law. But if it's after 1978, you got the regime of the SIA. Makes no sense, my lords. The root is section 9. Now, to conclude on this point, there's a degree of undue alarmism in the border respondent's case. And it's suggested that Zimbabwe's position on section 9 will require a full de novo rehearing in every case and render the award, I quote, of no evidential value. That's not correct, my lord, because in many cases, there'll be no dispute about arbitral jurisdiction. In others, it will be clear-cut. And where jurisdiction has been fought and decided in the arbitration, there are means which the commercial court is well aware of to use the evidence that was adduced, etc. And it's actually quite interesting because, my lord, the Chancellor referred earlier to the arbitration bill. And we've all been working very hard on this, and we really hope that it is going to become law soon. But the proposal to reform Section 67 was made on exactly that sort of ground. So you had a faction.
Well, it was the whole point about it was that was to try and avoid the situation where you had a complete rehearing.
That was the point.
And even though it's quite rare, there were occasionally complete rehearings. I conducted one myself in the commercial court. So I do recall.
Yes, yes, Mal. That's the point exactly. When they said, let's have an appeal. You can't have this. You've already been before the tribunal, you know.
Yeah.
And what's very interesting, and we know this, and it is public domain, because we all gave evidence together in front of the House of Lords Committee 3-4 months ago. But the commercial
committee
court,
that Mr. Landau was part of.
Mr. Landau was there, I was there, and the Mr. Justice Foxton and Mr. Justice
Yes.
Henshaw were there on behalf of the
Indeed.
commercial court.
Yeah, I know.
And the submissions by the commercial court is this is no issue. These alarm bells have been dismissed by commercial court judges, which is why we are retaining the de novo hearing in Section 67.
Yeah. Well,
But
because there are procedures that can be put in place to avoid abuse of that system.
They are already there and they're already being used. So a sort of compromise solution was reached where we gave to the other camp, you know, we may have rules of court. But I must tell you that the great hope is that there will be no rules of court because they already have all the case management powers.
Well, that's another story, Mr.
But we shall see. My Lord,
Yeah.
that is the scheme of the SIA. And if I'm
Yes.
right on that, my Lord, you don't even get to the interpretation of Article 54 because the root is Section 9. Clearly is. But let's look at Article 54 now, my Lord.
Yes.
The rules of interpretation. My learned friend covered Articles 31 and 32 yesterday. These articles of the VCLT are at A7101 3411. Yeah. We could turn them up.
I think we got them well in mind, really.
Yes, okay. I would make the following points on the exposition given by my learned friend. First, in terms of the material which one can have regard to under Article 31, this includes obviously the text of the treaty, the particular provision being interpreted, the context, especially, we agree on that, the other provisions of the treaty, the object and purpose of the treaty, which will normally be found in the preamble. The travaux, very obviously, my Lord, and if you want, we can have a look at it, but I think it will be obvious, do not fall to be considered at that stage of Article 31 when you're looking for object and purpose. The travaux are under supplementary means of interpretation under Article 32. Perhaps, my Lord, if you want to refresh your memory on that, that is quite an important point. Travaux are entirely separate, come at a second stage.
Yes.
Or the holistic, my learned friend is keen on this idea of a holistic approach under Article 31. We don't mind the terminology.
No.
But what is clear is that travaux does not form part of that. Now,
Just before we move on, in terms of object and purpose, you say that's mainly to be found in the preamble. I'm not sure that's in Article 31 itself. Is it clear from some other source? You say it's clear from Article 31, but you see in 31.2 it says the context shall comprise, in addition to the text, including its preamble and annexes. So at that stage, the preamble is context, or
yes, my Lord, I'm just trying to find the easiest way to show you that.
Yeah.
So, Mrs. Justice Dias, at paragraph 27 of her judgment, referred to Czech Republic against EMV, which makes it plain, and so that's A tab 612424, that the reference to other common expressions of intent are simply references to Articles 31 to A and B, which everyone agrees do not apply here. And her ladyship went on at 27 to say this, I quote, "The object and purpose of a treaty are to be found primarily in the preamble or that limited further material under 31 to A and B, and the court should be cautious before going further." My Lord, I apologize, I didn't anticipate that this would be controversial.
No, I don't suppose it is.
And it isn't. It isn't. You really, her ladyship, as you will see from her judgment, very careful, did not in the event go any further than the preamble, right?
No.
And certainly what you can't do, because at this stage, when under Article 31, primary means of interpretation, you don't go to the secondary means to detect and determine a purpose, which you then use in the first step of Article 31. Now, if I can please invite you to look at, in fact, what my learned friend has done in his supplementary skeleton at paragraphs 15 to 16 of his supplementary. So paragraph 15, the object and purpose of a treaty is primarily to be found in its preamble or other expressions of common intention, as Mrs. Justice Dias correctly held, and that is correct, and she does say that those expressions of common intention relying on the judgment in Czech Republic and EMV are simply the two other A and B of 31.2. They then go on to say the Supreme Court has also held that material identifying the object and purpose of the treaty may be found in supplementary material to which recourse is permitted under Article 32. My lord, that is incorrect. What they've done here is they've used one loose sentence of a judgment
Where's that judgment?
Of Lord Hamblin in JTI Polska. Yes, you have it, my lord. It is at A5, 57, 2322. Paragraph 32. And the sentence they're trying to use cannot bear the weight they're trying to put on it. So at 32, if you please look first at paragraph 28, you can see that by this point, Lord Hamblin is looking at Article 32, supplementary means of interpretation. And then he says at 32, the appellants do not suggest that the trouble will disclose a bullseye, etc. And in the sentence that my learned friend wants to rely on is on 2323, and the second full sentence. It may, for example, include material which helps to identify the object and purpose of the treaty or provisions within the treaty. Now, with respect, there is no authority cited for that. I think it's at this stage, Lord Hamblin, as I say, is already into Article 32 territory. And it is with respect contrary to all authority. And you can simply see that, my lords, from the very scheme of Articles 31 and 32 of the VCLT. Anyway, you can see we say this doesn't support the weight, but let's take it even more simply. My learned friend told you yesterday, oh, I don't need the travaux. It's very clear, it's very clear.
I mean, I read, looking at 32 as a whole, I don't know whether it makes any difference at the end of the day, but as I read it, what he's talking about there is actually resort to material within Article 31 for confirmation purposes. Isn't that right? Moreover, confirmation, so the bottom of page 2322, moreover, confirmation, so that's an Article 31 concept.
32, my lord, if you're in confirmation. So you use the supplementary means to confirm a clear meaning or to determine an ambiguous meaning.
The point I'm making, it's not really to do with the article numbers, it's to do with the fact what he's talking about is use of material for the purposes of confirming a meaning. So it's a very narrow concept.
My lord, my point is simple, is that the object and purpose are to be found in the preamble, not in the travaux. Object and purpose is step 1, travaux is step 2. Secondly, my learned friend told you yesterday, I don't need the travaux. I just want to show you what he has done in his skeleton. And we were looking at that, it's paragraph 16. In the case of the, and the most important and interesting bit of that whole paragraph are the footnotes. Overarching purpose is to promote the flow of private investment into areas in need of economic development by removing a key impediment to that flow, namely fear that investors would be exposed to political risk by host state action, etc. But each and every of these footnotes, one, when there is a preamble, it's glossed in the text. A gloss is introduced every time, but more importantly, extensive reference to the travaux. The final quote on page 7 of the internal page 7 of the skeleton, mitigating sovereign risk, that's not even in the travaux. That's in the judgment of the High Court of Australia, and the footnote you will see is actually quoting from the ISL claimant's skeleton, which I didn't realize were object and purpose of the treaty. But you will see that in the High Court of Australia's judgment, there is no reference, footnote, nothing given for that phrase, which is at the center of their case, mitigating sovereign risk. So not only has my learned friend used selected bits of the travaux, which he felt suited his purposes, but he has done so, we respectfully submit, in a completely impermissible manner, as purported object and purpose, And in order to conduct what, my lords? A totally impermissible exercise, i.e. one of teleological or purposive interpretation. Oh, you would proceed no differently if you wanted to pass off an implied term as an express one. Finally, on treaty interpretation, my lords, in terms of the proper approach to the implication of terms, if I could show you quickly our supplementary skeleton, paragraph 27. Just bear with me, I need to get hold of it myself. I didn't take one of those spiral binders, I should have. 27. If I could please ask yourself to read that to yourselves about the implication of terms. And once you've done that, if you would let me know, there's one correction and one reference which I would like to give to you.
Yeah.
Thank you, my lord. So the correction is that it's not Brown and Scott, but Brown and Stott to the T. And the reference is that the disagreement reduced to writing point. It's actually been introduced into the law report by Mr. Lendau. And you find it first in a footnote to paragraph 19 of Czech Republic and EMV. So that's A2, 29, page 989. And the footnote is at 999. The disagreement reduced to writing. And then that's picked up by Mr. Justice Bryan in GPF in Poland at A3, 42, 1590, paragraph 51.
So what's the footnote in
Footnote, I think it's footnote 10. Paragraph 19 and footnote 10, yes. Footnote 10 at 999.
Yes, got you.
Thank you. So,
I mean, in one sense, these words could be used to apply to the approach in England and Wales, but you say there is a more textualist emphasis.
yes, no, I don't want to put the point too high, but I think there is a danger because, and I include myself within that, we construe contracts day in, day out. Treaties are not contracts.
No,
And
that's the point, isn't it?
Well,
That's the point. I mean, the real point is there's a different method of construction or interpretation. So we
absolutely.
need to avoid simply coming at it with a contract lawyer's.
It is a
mindset.
mental exercise you need to make, my lord. You need to transport yourselves from this courtroom into the Peace Palace at The Hague, which, as the Supreme Court in Mikula has said, will ultimately one day probably hear the case about the true meaning of Article 54. But that is the exercise we need to make. We cannot use purposive interpretation. We cannot say, oh, it does look like Attorney General in Belize, of Belize.
No, sure.
We just can't. And in the same way, you could see immediately yesterday the analogy with the parole evidence rule insofar as travaux is concerned. There is one, actually, yeah, I'll show it to you quickly, that really doesn't work because it's got its own rules. If you look at the authority which you have at A8,
Yeah.
tab 142, Page 4251.
Yes.
Internal page 629, which was exactly to your point, my Lord Chancellor, the confirm the meaning.
Yeah.
And if you look at the second paragraph, sorry, it's paragraph 31, they are numbered on the right-hand side.
Yeah.
However, as Gardiner rightly points out, investigating travaux to see if it does in fact confirm a particular meaning arrived at by applying the general rule carries with it the implicit possibility that it does not do so. In that case, the interpreter will have to reconsider its position. Thus, confirm entails the option of not confirming, and the possibility of transforming the exercise into one where the preparatory work leads to a revisiting of the application of the general rule to find a permissible interpretation, which is then confirmed. The investigation may also lead to the conclusion that there is an ambiguity that has hitherto gone unnoticed, such that the exploration of the preparatory work is transformed from a potential confirming rule to one of determining the meaning. So if, for example, you know, if something looks, well, it looks like that, but in fact, as I've showed you, it may look like that. But that's only because you're ignoring the fact that the obligation is created on the public international law level, will bite in any event, and that we're now talking about whether the creation of an enforcement mechanism necessarily brings with it submission to that mechanism. And then you go to the travaux, and it shows you, well, there was never any intention to waive any state immunity. That we respectfully submit.
I'm sorry, I think you're going to have to give me that reference again. Can you give me the reference?
To this text? Sorry, my lord. A8,
Yes.
tab 142,
Yes.
and the passage is at paragraph 31, which is at page 4251.
Thank you.
And just to understand, the Gardiner is cited. What jurisdiction is Gardiner from, or is he a writer?
He's a writer. Presumably, it's the same gentleman as in tab 8. Is it?
It was not. He was at the SU, I'm told, but not legal advice.
Tab 138 is an extract from Gardiner's book
Yes.
on treaty interpretation, I think.
I think it will be obvious where that reference came to me overnight.
I think, am I right?
So I'll deal now with the interpretation of Article 54 quickly, because I think you've got all my points.
Yeah.
My lords. It's effectively what we've said in our handout at paragraph 3. There is no language of submission, there is no language of waiver. Rather, what is being said is that one should infer from the obligation to create a mechanism for enforcement on state A, a submission to the enforcement mechanism before the courts of state B. And for the reasons I've already given you and that are in paragraph 3, we say that's wrong, and that actually NML is excellent to illustrate why it's wrong. In NML, you have an obligation to enforce in certain jurisdictions in a contract. That makes no sense if you can't in fact enforce. Whereas here, you have an obligation to create an enforcement mechanism. We've done so, the UK has done so. Whether Zimbabwe separately agrees to submit to that enforcement mechanism is a completely different question. The distinction between the PIL obligations, public international law obligations on state B and the domestic regime being created are within the text of the convention itself. I've shown them to you, it's Article 27, 53.1 compared to 54. In terms of object and purpose, I've showed you the preamble, and we say what you take from the preamble is quite simply that this is a convention, the purpose of which is the creation of an optional mechanism based on consent.
Can I just try testing it the other way? So we're on Article 54, which on the face of it doesn't merely say each contracting state has to create a mechanism. It says it has to recognise. So Zimbabwe as a contracting state is agreeing that the United Kingdom as a contracting state is to recognise an award rendered pursuant to the convention and enforce it as if it were a final judgment.
On the public international law level. There are two ways. There's perhaps a slight ambiguity in 54, and the question is whether, but it doesn't matter, is whether recognize an award rendered pursuant to this convention, sorry, whether the word within its territories applies to both limbs, if you see what I mean. Recognition and enforcement, or only to enforcement. But it doesn't matter, because say recognize is separate, and it's not within its territory, so it's not something that is part of the enforcement mechanism. It is an obligation owed by Zimbabwe to the United Kingdom. Absolutely. And Mikula says that, and we accept that. So what does that mean? That if tomorrow Zimbabwe is non-compliant for reasons which the United Kingdom strongly disagrees with, they can bring a case under Article 64, before the International Court of Justice. That's at the PIL level. But then so that is doing that, and I would say, so far as Zimbabwe is concerned, this is not, if it is a separate obligation to recognize and enforce, it does nothing more than Article 53.1 because it's already a disputing party. About the enforcement mechanism, this clearly creates an obligation to create the enforcement mechanism.
It doesn't say that. It says this involves Zimbabwe agreeing that the United Kingdom shall recognise. It doesn't say shall create an enforcement mechanism.
It's the words within its territories, my lord, and then when you read that together with 54.2 and 54.3, and it becomes clear that the purpose of this is to create an enforcement mechanism, which is in fact what then happens.
Within its territories, yes. And that's the point. The words within its territories qualify the words enforce the pecuniary obligations imposed by the award.
Yes, my lord. So that
and this is an award. I mean, leaving to one side your point about this convention not having as its primary purpose or whatever, awards against states on behalf of investors. But for better or worse, that is the sort of case which has emerged under ICSID over the years.
And no, that was the purpose. There was going to be awards against states.
What one is postulating is an award against Zimbabwe in favour of these investors. And what this article is saying is that the United Kingdom will shall recognise that award and enforce its pecuniary obligations within the United Kingdom as if it were a final judgment of the United Kingdom court.
Yes, my lord. And in order for the United Kingdom to do that, because we're a dualist system, it has to create an enforcement mechanism. And irrespective of whether you have to do that or not.
But it may have to do that, but that's not the obligation that's being dealt with in Article 54.
But my lord, if it doesn't have to do that, then we're not even in the realm of what we're discussing here, which is whether there's submission to that mechanism.
Well, why isn't it true to say that Zimbabwe, by becoming a party to this convention, agrees that the United Kingdom is to recognise as binding and enforce within its territory the award?
My lord, the one bit which is missing in your sentence and which you cannot, which we can't do away with, is at what level? You've got the word within its territories. So if we're simply saying Zimbabwe agrees that that is what the United Kingdom has to do, and Zimbabwe is not complying with it, etc., then Zimbabwe is in breach at the international law level vis-à-vis the United Kingdom, and the solution for that is the ICJ.
But that doesn't make much sense. I mean, why would the United Kingdom complain to Zimbabwe?
The application to recognise and to enforce the award is an application that's going to be made by the award creditor, for obvious reasons. The United Kingdom in itself is not interested in enforcing the award.
Yes, no. So two answers to that. One, the host states of the investors might be, and they are also called by these obligations. Secondly, I didn't think it was controversial that this does call for the creation of an enforcement mechanism. That is in fact what has happened, because the whole debate we are having is that it is being said you're agreeing to be to submit to the jurisdiction of that mechanism. So if there isn't a mechanism, then there's nothing arising.
I mean, I dare say we'd be in breach of something if we didn't have a mechanism. In fact, there was. And there has for a very long while been a mechanism.
Yes.
But why should it be construed as limited to creating the mechanism when it seems to involve Zimbabwe agreeing that the United Kingdom must enforce the award?
No, I'm not saying that, my lord. I'm not saying it's necessarily limited to that. I'm simply saying that the fact that you're obliged to create something on the domestic law level, which is very clear from the words within its territories, doesn't mean that when you've created that, every other state agrees to submit to it. That may or may not be the case. And what I'm telling you is that, let's say that's an ambiguity. I take your point. Then you go to the travaux. And what do the travaux tell you? That the basis of everything was that states would comply, and that when they didn't, the obligation inter se would be at the public international law level. And that the transposition on the domestic field was being made in order, I'm not putting it any higher, but in order to give to give states a forum to get costs back from investors. So that has to be construed
None of that appears from Article 54.
No, Manu, but Article 54 doesn't say, again, all that Article 54 can do is create an obligation on the public international law level between two states. The highest that one can put that obligation, yes, recognize, yes, enforce, that's all at the PIL level. We only get to the question that we are dealing with in this appeal, which is submission to a national jurisdiction, if a national jurisdiction exists. Therefore, you must have the step of creation of a mechanism under domestic law.
There might already be a mechanism.
Oh, there may be, my lord. Let's say there may be. So they've complied with their obligation before the convention is already there, but there is that mechanism. It's not the fact that you need to provide a mechanism, pre-existing or creating, that means that every other state necessarily agrees to submit to it. The obligation is to have the mechanism. It may or may not follow that you submit to it. Sorry, my lord.
You say it's exclusively on the international law level. Why?
This is a treaty, my lord.
Well, can I just pick up your point 5 and answer the questions?
Oh, yes.
You say, in dealing with the question of whether a treaty clause saying all contracting states
We've gone
submit
too far.
unequivocally, blah, 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 you say, well, yes, that would have been submission. Well, that would still have been in a treaty.
Hmm? Could you repeat the question, my lord? I'm sorry.
I understood you a moment ago to say, well, it's on the international law level because it's in a treaty.
Yes.
But if this wording that you set out at 5 had been in a treaty, it would still have been in a treaty, but you accept that there would then have been submission.
Because Article 17.2 brings the submission back to the domestic law level.
In which case,
It's not automatic.
Sorry, but in that case, why is it an answer to say, well, 54 is in a treaty, therefore it operates at the international law level, not at the domestic level?
No. So what I'm doing is meeting the test under English law. And what I'm showing you is that it does not follow inevitably from this wording that there is a submission to the enforcement mechanism. There is an obligation to create or to have in place already existing an enforcement mechanism. You can only get to say, and you submit to it by a process of implication, which is what Royal
Well,
tells us.
you're answering your point 5 to accept that if Article 54 said somewhere within that first sentence that and the state against the contracting state against which the award is made will submit to the recognition, to the said recognition and enforcement, something of that kind. You accept that would give rise to
Yes, and also the obligation is still at the international law level, but a combination of Section 2.2 and Section 17.2 brings it into the Section 2.2.
So one comes back to the same point, which is simply the point as to whether Article 54 has that meaning and effect in any event. irrespective of whether those words are written into
With
it or not.
With respect, my lord, it's a bit more. It's not that simple, because it's whether it's expressed. It is expressed or implied.
No, it's not whether it's expressed or implied. It's what is the true meaning of the words used.
My lord, we agree again.
Say anywhere it has to be that it's an express or implied thing. I mean, I follow the point about implied waiver and so forth, but the fact is that the process, even though you're quite right, it's not the same process as construing a contract. It's still a process of looking at the words used and deciding what their meaning and effect is.
Yes, my lord, it is agreed in this appeal that given the way the test works and the international law authorities, you will only be able to say that the process of inference, let's call it the process of inference, remains express if the consequence is inevitable. And my point is, I'm sorry to repeat it, but it is very simple. It does not, if I may, my lord, just to finish my answer to my lord, the Chancellor, it does not follow from an obligation to have on the in the municipal sphere a means of enforcement that every other state submits to that means of enforcement.
If we interpret what is the right meaning, then it is inevitable.
Yeah.
Because that is the right meaning.
Quite.
Well, on that logic,
It's a circular argument, that's the trouble.
Can I ask you this? On your wording in answer 5, or the wording that you picked up and said yes to, as I understand it, the only thing that's missing is the word submit.
no, my lord. What is missing is step 2. So I'll repeat it one last time. There are 2 separate things. One which is have in place in the municipal sphere a way to enforce and recognize this award because investors might need it. Let's say that. The other is, and you've submitted to it. The 2 are separate. 2 may or may not follow from 1. It is not at all inevitable. And perhaps, my lord, I'm very aware of time and I need to leave 20 minutes.
That's your argument.
That's my argument. But
I think we really must have a break now.
My lord, can I conclude on that one point? Because then I don't need to come back to it. Which is that this sort of obligation to have a remedy under domestic law arises in many, many, many conventions. And it's never been suggested that it follows inevitably that because you've agreed to create a remedy on the domestic law level, everyone else who's a party to the convention has agreed to submit to that. And we say you must read it carefully. I will not have time to go through it. Pinochet is directly on point. And the ECHR, the ICCPR are the same. Those are my submissions, my lord, if you want to have a break.
Well, I'm very conscious that you seem to be cramming in a lot of really quite difficult points in
My lord,
a
I'm going
short
to
period of time, and I don't want you to feel that you haven't had the opportunity to make the points you need to make, Mr. Newey. Speaking for myself, I've endeavoured to keep quiet. Perhaps not very successfully, but I have tried.
There's absolutely no point in your keeping quiet. I mean, the whole point of this is the exchange, and I've thoroughly enjoyed it, my lords.
Let's take 5 minutes. I'd like you all to think very carefully indeed about whether we really are going to finish this case by 4:30, because I have considerable doubts. 5 minutes.
All rise if able.
Fine, I've got 2 questions. Yes. I can look at them actually. Let me see them.
No, I think it's.
Get back. unless we get where I want. I just need to show them what's shown. Come on, Benedict.
Okay.
You know, I've been with Toby giving me like 3 minutes to make submissions.
I know.
On the travel of the your convention, so it'll be great.
Sorry, I don't have volume.
That's okay.
Tab 1, 2, 3, 3, 2, 9. What volume is it?
8.
Yeah, what this is.
Yeah, it's a different highlight for every party's taking this off for it, so I can see where we're being.
That is very smart. I do that a lot like that. And someone color coding in is oh, we can even label the.
So I don't go with this. I find it useful later on with your standing grounds or something, and then you know you can go back through, or even sometimes where I forget to click into one. It's really good.
So you set up highlights for every case.
Well, that's sensing. That's quite fine. Quite efficient.
Show them that and nothing else, and they can just we have one.
We need to try and do it in 20 minutes. We have done that.
Yeah.
We need to finish it.
Yeah, I know.
It's always a problem. It's like, don't look at the contractual negotiations, but if they're in one. We don't need any software for us.
Yourself plus if you're busy at the moment.
I think no problem.
Yeah.
But they're wrong. No, I know. So that's because you're
Yeah,
I wasn't. The questions. I was like, what?
All evidence rules.
Yeah, I was like, why? So I was like, no. Yeah. No.
I have one, but it's slightly loud. So I just kind of For the rest of Court rise if able.
My Lord, on the point that you raised just before the break, so, and I haven't spoken myself, but, and no doubt I'll be corrected, but I understand that the collective view is that no one wants an overrun.
Surprise, surprise.
But obviously we are in your hands. So that is from us at the bar. My learned junior was very persuasive in making me understand that the last 10 pages of my notes were not necessary. I've just got 2 points that I will make, and then I will sit down, and then hopefully Mr. Tompkins can be no more than 25 minutes, and then hopefully we'll my Lord.
Just so we know, I mean, I haven't spoken to my colleagues as to how late we could sit. Now, there is an issue, given we started at 10 o'clock, there's the obvious issue of diminishing returns, if I put it that way.
Yeah.
The day wears on and everybody gets tired, and it's, you know.
Lord, it's right, as my learned friend says, it's quite right. The council are obviously in the court's hands. If you need our assistance, we will assist you. And how is a different question. If you want us to put additional reply points in writing rather than orally, we can do that. If you want to schedule further time for hearing, we can do that. The only point I would make is this. All the parties so far have confined themselves to the times. We had 1 day and the other parties gave us a little bit of extra time. We always said that was going to be tight, but the other parties gave us a little bit more time. We have split it equally. I confined myself precisely to the time that we agreed. Learned friend said yesterday he wanted a timetable, and we agreed one last night. And I confined myself precisely to that time. And I cut pages of notes for that. And I kept 30 minutes for reply. You'll recall I told you that earlier. If my learned friend spends another 5-10 minutes developing his point, then Mr. Tompkins spends 20 more minutes. He's already had more time than I spent. There's no way to finish by 4:30, still less Mr. Green or Mr. Balloch having any further points. So I'm fine for my learned friend to get on. I don't want to waste the court's time, but it's just a flag that we on our side are not comfortable with a sort of compression with total freedom from the learned friend to continue.
Well, there was no idea of total freedom, and I think we're losing time rather than using it.
I think we are, and
Yes.
it doesn't do any good.
Yeah.
I think your side, Mr. Rowland, should do it utmost to finish by 4 o'clock.
Yes, my lord, we shall. So, just 2 points from me. On the travaux, it's all covered in our skeleton. There's one passage I want to show you, which is in A9, tab 155, page 4560. And my lord, this is still at the time when you've got section 15, unitary provision, not split between execution of a judgment and enforcement of an award. And you see at the bottom of that page 345, internal, the United States of America, Mr. Lowenfeld, suggested that the convention provide that when a state manifested its consent to the jurisdiction of the center in any of the ways indicated in Article 2, Section 2, so that's effectively Section 25, it might be presumed to have thereby waived its sovereign immunity in respect of the enforcement of an award. The chairman agreed the suggestion might solve the problem that was being discussed with Guatemala, but would run counter to the basic presumption of the convention that states would live up to the obligations which they assumed thereunder. And we do say, my lord, that to now find a waiver of state immunity from adjudication in this convention would not be a good faith interpretation of the treaty. So that's one short point. The other short point is just to give you a reference on specificity to an article. So that's literally 30 seconds. And in any event, you've got our point on NML, which is the main point. But there's an article by Professor Yang, the respected authority on the law of state immunity, which is cited by Lord Bingham in Jones and Saudi Arabia. The reference is A227 at paragraph 34, page 917. And at A8, tab 133, pages 4110 to 4111, he explains the test of specificity, and we rely on that. And we say, as a second alternative argument, that Article 54 falls foul of the test. So just to recap my three arguments on Section 2, my lord. We say the scheme of the SIA shows you it's not Section 2, it's Section 9. And we say respectfully that is a complete answer and a simple answer. Secondly, Article 54 does not operate as a submission for the reasons I've given you about the text of Article 54. And thirdly, also there is no sufficient specificity. Thank you, my lord. Mr. Tompkins will now take you through the
But, my lords, the issue is whether the Section 9 question, has a state agreed in writing to submit a dispute to arbitration, is always or necessarily discharged in relation to an ICSID award, because the court is bound by that ICSID award. So Zimbabwe's headline answer to that is no, the award can't be preclusive because that assumes the existence of an arbitration agreement conferring relevant jurisdiction on the ICSID tribunal, which is the very thing Section 9 requires to be established. So I'll be as brief as I can, making that good. Two references to Mrs. Justice Dias's judgment below, and these are just now for your note, and I'll tell you what she says. They are paragraphs 84 and 88. And in the first paragraph, the judge explains that while the ICSID regime is self-contained insofar as challenges to the award are concerned, Section 9 is a different animal. It's the gateway to the disapplication of the Section 1 immunity. And so the fact that the question you ask to go through that gateway or not might overlap with the internalized grounds for challenge to an ICSID award is neither here nor there. You're asking and answering a question for a different purpose.
Yeah. And
then at paragraph 88, Mr. Justice Dyer says the following. Section 9 is of general application. It seems to be irrelevant that the ICSID is a self-contained regime under which the ICSID tribunal is the final arbiter of its jurisdiction. Unless there was in fact an agreement to submit a particular dispute to ICSID arbitration, the ICSID process should not by rights be engaged. So that analysis captures the point perfectly insofar as we're concerned. The first way round it, attempted by my learned friend on this appeal, is put in terms of statutory interpretation. It said Section 9 should be interpreted effectively to give direct effect to 41, 53 and 54 of the Convention as a matter of English law by saying the tribunal had jurisdiction to determine its own jurisdiction. You can't review that, the award must be enforced. There are two reasons why that doesn't work. The first is what Section 9 requires as a matter of English law is that a claimant against a state prove that there exists an arbitration agreement before the court can exercise jurisdiction over that state. Now, it's true, of course, as a matter of public international law, contracting states, all of them, including Zimbabwe, agreed to the obligations in 41, 53, and 54. But the question in this court arises under the 1966 Act in this way. Section 2.1 of that Act, A2, page 22, volume 1 of the bundle, says a person seeking recognition or enforcement of such an award shall be entitled to a registration order. That's how those international law obligations in the ICSID Convention are given effect in English law. The key point is if the Section 9 exception is relied on as the exception to state immunity, that is the gateway you have to get through in order to have that recognition or enforcement. So the problem with my learned friend's argument, first problem, is if it's a gate, Section 9 opens the gate. What you've got to do to open the gate is find there existed an arbitral award, and you can't use something on the other side of the gate to open the gate, or to put the metaphor differently. Section 9 unlocks the door, and you can't rely on something which is behind that locked door to do the unlocking. So that's the first problem. The second problem is taking the ICSID Convention on its own terms, 41, 53, and 54, on the international plane, but taking them on their own terms. They are only engaged if there is a freestanding arbitration agreement between the investor and the state. And that's the Article 25 point, which my Lord Justice Newey alighted on in the debate with Mr. Harris. The convention only applies if there's a valid arbitration agreement giving the tribunal that jurisdiction apart from the convention itself. And the source in this case of that putative arbitration agreement is two things: the offer in the BIT and its acceptance or purported acceptance by the putative investor. And my Lord the Chancellor was discussing earlier with Mr. Moulin whether certain matters are jurisdictional or non-jurisdictional. The critical point is the offer is an offer on terms. It's an offer to arbitrate particular disputes with particular persons. So you do, Section 10.2, which is quoted in the award, is only part of it because that uses defined terms from the rest of the agreement. So illustrate the point a bit more vividly. Some BITs, not this one, but some BITs, offer only to arbitrate disputes about quantum. That's it. Merits are expressly reserved to the domestic courts of the host state. And if an investor came along and purported to accept that offer, but in relation to disputes about the merits, that would not result in an arbitration agreement. And Zimbabwe says in this case, in various ways, like that, not that because that's not how BIT, but in various other ways, the offer was not open for acceptance by these investors. And the point that those points have been resolved against us by the tribunal is neither here nor there, because my learned friend says the reason you cannot reopen is Article 41, but you only get to Article 41 if the offer was properly accepted. So that's not an impermissible challenge to the integrity of the award. It's just a function of this particular gateway being governed by the question, was there a valid arbitration award, which just so happens to be one of the internalized arbitration agreement, which just so happens to be one of the internalized grounds for challenge. But you're not challenging the award. You're trying to answer the Section 9 question. So put it a little bit differently. Section 9 asks, is there a valid arbitration agreement? Answer there comes from my learned friend, Mr. Harris. Yes. And in fact, you must say yes, because one, the arbitral tribunal said so, and two, they had exclusive competence to say so under the convention. And Article 53 and 54 say the decision must be recognised and enforced. But that begs the question, on what basis did they have exclusive competence under the convention? Answer there comes back, because there was a valid agreement to exit arbitration comprised by the offer and its acceptance. And so you're back to square one. That's the Section 9 question. You can't answer it internally to the exit section, the exit system. That leads on to estoppel, which really, once you pull the threads, is just a variation of the same argument, and it suffers from the same problem. And that's because the starting point, and it's an uncontroversial starting point, is that for an arbitral award to give rise to an estoppel, the arbitral tribunal must have jurisdiction. And that jurisdiction must come from somewhere, the consent of the parties, an arbitration agreement, or a court order, or a statute. And that's made clear by the passage from Spencer Bauer relied on by my learned friend, Volume 9, tab 153, page 4516.
Sorry, Volume 9, tab
153,
yeah.
page 4516.
Yeah.
But my lords might immediately perceive the problem though. It's not just any estoppel that is trying to be set up against us here. It's a purported estoppel on the existence of something which must be established before the award can give rise to an estoppel. That's the inherent circularity. And we've had three ways in which they try to get around that today. First, reliance on the ICSID Convention itself again, which gives rise to the same problem we've just been discussing. And I'm going to show you a domestic case which shows why that doesn't work as a matter of English law in a second. Second, reliance on the case law, which shows that a foreign court judgment might give rise to an estoppel on the Section 9 question. And third, in my learned friend Skeleton, there's a paragraph from Spencer Bauer and Handley which says that arbitral tribunals might have authority to determine facts going to their own jurisdiction. And none of those work. So first of all, the convention and the BIT, again, I'm not going to repeat what I just said, but what I would ask your lordships, if I may, is to turn up, please, the LG Caltex case,
Which is
Volume 9, tab 159, page 4746.
yeah.
Paragraph 45 describes the argument which Lord Phillips in that case was dealing with. The argument was, in a nutshell, in this case, there exists a separate ad hoc arbitration agreement submitting to the tribunal the issue of the validity of the contract. And if that tribunal finds that the contract is valid, that means that an arbitration agreement in the contract would therefore be valid, and so the tribunal would have jurisdiction to determine questions under the contract, in that case damages. So in the words of the judgment, the ad hoc agreement alleged was an agreement purporting to confer on the arbitrator jurisdiction to determine whether he had substantive jurisdiction. And then over the page in paragraphs 49 and 50, Lord Phillips explains that such a separate and prior agreement could conceptually confer jurisdiction on an arbitrator to determine whether they had jurisdiction. But the rub is in paragraph 50. If it is shown that the award is made under a separate agreement that the tribunal should rule on the matter, a challenge to a jurisdictional finding in that award will fail. Thus, in the instance case, there's been no bar to the applicant's right to challenge in court the awards. Before the judge below, however, that challenge has failed because of the finding on the ad hoc agreement. So because of the finding that the ad hoc agreement was valid and conferred jurisdiction. And then over the page, the heading to what was issue 3 in that judgment, was there an ad hoc submission on the issue of whether the parties were bound by the two contracts? So the external validity, the jurisdiction of the tribunal to determine its own jurisdiction in LG Caltex came from a separate arbitration agreement. They call it an ad hoc submission. You could call it a sort of meta arbitration agreement. But this, if you go up to that level and there's a challenge to the tribunal's jurisdiction under the meta arbitration agreement, the tribunal can't determine its own jurisdiction at that level. And in this case, Zimbabwe challenges essentially the meta arbitration agreement. My learned friend says in an ICSID award, the two are smudged together. You've got both the arbitration agreement to determine the merits, and by operation of the ICSID convention, you've got a separate agreement but constituted by the same documents, which gives the tribunal the jurisdiction to determine its own jurisdiction. But what Zimbabwe is saying is, no. Because you investors didn't accept the BIT on its terms, there was no meta-jurisdictional agreement. So the criterion in Article 25 of the ICSID agreement is not satisfied, and you can't set up your estoppel. And that's all that this goes to. the result is there's no estoppel. You've just got to ask and answer the Section 9 question on its own terms, which was what my learned friends for Spain and ISL spent the better part of 2 days doing on the intra-EU question. Next, the analogy with recognition and enforcement of foreign court judgments. The best way into this is the recitation by Mr. Justice Cockrell in the second Hulley and Russia case of the good challenger principles. And they're at volume 5, page 2361. Perhaps don't turn them up because you will recall the good challenger principles. The first of them is, did the foreign court have jurisdiction? So just like with arbitration and estoppel set up from an arbitration agreement, it is a precondition to an estoppel set up from a foreign judgment that the foreign court was of competent jurisdiction. And the English court, in considering whether as a matter of English law there's an estoppel, has to ask and answer that question. Just as in determining whether there's an estoppel arising from an ICSID award, it has to ask and answer, was there jurisdiction for the tribunal to determine its own jurisdiction? Was Article 25 satisfied? Therefore, was the offer in the PIT validly accepted on its terms or not? And Hulley rather proves our point that what happened in Hulley was an estoppel was found as to the Section 9 issue. So Russia was in that case stopped from contesting the existence of the arbitration agreement. But the estoppel came from judgments of the Dutch courts, which were the courts of the arbitral seat. So they had jurisdiction as a matter of both private international law, English private international law, and as a matter of Dutch general law. If there were ever some question about that, if it was decided by the wrong Dutch court, some Dutch labour tribunal, you could challenge that, and there would be no estoppel.
Okay.
Third and final argument arises from a quotation of paragraph 41 of my learned friend's supplementary skeleton. If we can look at it, please, it's bundle C, tab 12, page 205, or if you're working from the separate bound versions,
Yeah.
it's on internal page 20. Paragraph 41 quotes from Spencer Bauer. It says the jurisdiction of the tribunal may...
Forgive me, I haven't got there yet.
My apologies.
So, can you give me the reference again? It's
Bundle page 205 of the core bundle.
thank you.
And the first sentence of the quote from Spencer Bauer is, the jurisdiction of the tribunal may depend on its findings that certain facts exist, and in that respect it may be made the final judge of its own jurisdiction. Footnotes have been omitted from that quotation, and the reason I'm spending my last few minutes of it is that I can't leave it unanswered, because if you do go to the case cited in the footnote, it in fact says completely the opposite. So I was a bit embarrassed yesterday by taking the CPR at face value. This is a similar but more profound problem. The authority is at tab 168 of the additional authorities you've been given this afternoon.
Yeah.
It's a judgment of the Exchequer Chamber, so an appellate judgment on a common law action on the award from 1870. The page with the relevant passage on it and the page cited in the omitted footnote in that paragraph from Spencer Bauer is page 232 of the report. You're with me on page 232. The Exchequer Chamber says, now it may happen that the same question may arise either as a question of jurisdiction or on the merits within the jurisdiction. Difficult to say whether the jurisdiction is exceeded or not. And then after the citations, it goes on. Now in cases where an award is good on the face of it, but the arbitrator has made a mistake, either of law or of fact, if the mistake has been as to a matter within his authority, inasmuch as there's no court of appeal from the arbitrator, the mistake cannot be remedied and the award can't be set aside. But then a few lines down, but if the mistake has been as to the extent and nature of the arbitrator's authority, leading him to exceed it, then inasmuch as an excess of authority by mistake is just as much an excess as if it had been in consequence of a wilful regard of the limits of the authority, the award may be impeached as being made without jurisdiction. Were this otherwise, no one who submits to a reference of one thing could be safe from having an award put upon him as to anything else. So completely the opposite of what the paragraph from Spencer Bauer says in that first sentence.
But forgive me, what all this really matters, all of this law and reasoning is fairly trite in relation to section 67, isn't it? And what your, at the end of the day, what your submission is that that is what is engaged in section 9, even though you accept that it's not engaged in relation to section 1 of the 1966 Act.
It's because the two sections are doing different things. Section 67 asks, did the tribunal exceed its substantive jurisdiction for the purposes of deciding whether to set aside the award or not? You can't ask that question in relation to an ICSID award.
No, but you can in section section 9.
Section 9 asks, was there a valid arbitration agreement as a precondition to this court exercising its jurisdiction under the 1966 Act? So it happens to be the same question because that's how Parliament framed the range of exceptions. But you're not challenging the award. It's the statutory requirement or the relevant statutory requirement for this court to exercise its jurisdiction as a matter of English law.
Okay.
That's all I had to say on section 9. Very, very briefly, ground 6 is the due process point.
Yeah.
This was not just a unilateral reservation by Zimbabwe. It was, in fact, embodied in the commercial court's order as to the way these proceedings would be run. And it's Mr. Justice Jacobs' order. He says there will be a phase 1, then there will be a phase 2, and that is subject to the reservation as to non-immunity grounds. So it's in the order. And not only is it in the order, there was a very good reason to structure the proceedings like that, and that is because Zimbabwe cannot advance non-immunity arguments while maintaining its state immunity. Because if it did, section 2(3)(b) of the SIA would disentitle it to the immunity, so it would be self-defeating.
So if it's in the order, do you need anything from us?
The appeal against the setting aside of the order of our application to be dismissed, so we can go back to Mr. Justice Dias and do exactly what the order says is the next stage if we fail on immunity. And what that is to properly articulate, plead and prove the non-immunity grounds that we say we have.
Yes, Mr. Harris.
Lords, there are a large number of points, I'm afraid, to cover in reply, but I'll try and be as brief as I can. Can I start by saying this, that I said you would see a lot of travaux. That's where my learned friend began. It's where he went through. And when you come to the end of your notes, you'll remember that the one thing throughout my learned friend didn't take you to was Article 54. And that's striking in my submission. But Lord, the fundamental point my learned friend made when he was taking you through the travaux, and the reason he said he was taking you through the travaux was he kept making the point that says fundamental, it was not intended to change immunity. The convention was not intended to change immunity. But on a proper reading of those travaux, which takes time, I'll try to show you shortly, just to make good the point, but on a proper reading, it is clear that what is being discussed is immunity from execution, not adjudicative immunity. Lords, let me just try to make that good as I can, because we set out all of the references and quotes, I should say, in paragraph 35(1) of our supplementary skeleton. So we've given you all the references and quotes there, which show why that is the case. Can I just show you two passages of the Travaux? So what happened is you have all these discussions, and that is what then leads to the introduction of Article 55 about execution immunity, i.e. the issue of immunity changing was raised. The consensus was clear that immunity would not change, and they made that clear by introducing the provision on execution immunity, i.e. Article 55. That's why I was submitting to you yesterday, it's so dangerous to look at these Travaux quickly and without care. Let me just take you in volume 7 at tab 118. If you could go on to page 3789, my lords. This is the Santiago meeting, just to place it, in February 1964. So it's one of the consultation meetings. And you can see that Mr. Rattray from Jamaica, the Jamaican delegate, raises his confusion about whether the intention of the convention had been to derogate from the doctrine of state immunity. And whilst it had been dispelled, there were good grounds for claiming that such immunity was excluded. And the chairman agreed that it was essential to make that completely clear and suggested that something along the following lines might be inserted. Nothing in this provision shall have the effect of derogating from the respective local laws on the subject of state immunity. He observed that a precedent for the provision in the proposed Section 15 existed in the treaty establishing the European Economic Community, Article 192, which is then set out. And you'll see Article 192, forced execution shall be governed by the rules of civil procedure in force in the state. The writ of execution shall be served. It's all about execution. And if you turn on, just as an example, to page 3801, a later meeting. In fact, sorry, turn to 3790 first. So just following the following page from the page we were looking at. There's further discussion, and Mr. Lowenfield of the United States raises a point, and just below the second hole punch, or alongside the second hole punch, the chairman, Mr. Brockers, again says, fifth line down towards the right-hand side, he invited the attention of the experts to Article 192 of the Treaty of Rome, which had excluded enforcement against states. He thought this exclusion had been based on the same reasoning that had led the staff of the bank in drafting the present convention to think that forcible execution against states should not be provided for. And he goes on to explain that. They're not doing execution. 3801, forgive me, which I was going to take you to, down just below the second hole punch, the chairman emphasised that the intention was not to modify the existing law on state immunity. The view had been expressed at the Santiago meeting, that's what I just showed you, that Section 15 is now drafted would force a modification in state practice and law on the question of a state's immunity from execution. 3801, my lord. 3801. Apologies. It's the sidebar text, bottom of the page. The chairman emphasised the intention was not to modify the existing law on state immunity. View expressed at the Santiago meeting, which is what I was just showing you, that Section 15 is now drafted would force a modification in state practice and law on the question of a state's immunity from execution. And then at the bottom of the page, the lack of uniformity in state practice concerning immunity of states from execution. And this is just one example, my lords, of why we say it's so vitally important that you look at the final product, the text, for the meaning, not the travail. And the last time I will mention travail, I hope, my Lord, my learned friend sought to make a point, a forensic point, saying, Mr. Harris says, oh, you can't look at travail, but then look at his supplemental skeleton, paragraph 16, it's all about travail. But that is simply misconceived. All we've done in that paragraph, as my Lord, the Lord Chancellor identified, is identified the preambular paragraphs that show the object and purpose of the ICSID Convention and explain what those mean, and then provide the references in the travail to confirm that meaning, which is precisely what you're allowed to do under Article 31 and what the United Kingdom Supreme Court in JTI Polska correctly said is permissible. So that's dealing with that, travail. Lords, on the High Court of Australia decision, obviously, in the interest of time, we haven't gone through it together carefully, but I can safely say that the court will read that carefully. The one point on it that I must pick up, my learned friend submitted repeatedly to you that it was a finding of implied waiver, and that is simply not correct. I quite accept the High Court of Australia judgment does refer in one or two paragraphs to implication, but it is clear when you read what they are saying in context.
Well, that's what I thought.
That what they're talking about is the meaning being the necessary consequence of the language.
Yeah, that's what I thought when I read it, Mr. Harris. It didn't seem to me true it is they refer to the United States cases.
At the end.
At the end, by way of sort of confirmation of the decision they reached. They also refer to the French case, actually, the Cour de Cassation case.
And they begin with Pinochet.
Deciding the case on that basis, I don't think.
No, they begin with Pinochet. So they were very clear what they were doing. My Lord, my learned friend repeatedly told you that Professor Schroyer has the view that there's no submission and it doesn't work, and he took you to Bundle 8, tab 123. It may be, Lord, he took you to page 3927 in Bundle 8, tab 123. And he read the sideline text. But you have to read from the word therefore. Sorry, yes, you have to read the previous line. However, my learned friend started from therefore. You have to read the previous sentence. So you've got the convention provides that each contracting state shall recognise and enforce an ICSID award as if it were a final domestic judgment. However, it also reserves the validity of state immunity rules in the contracting states. Therefore, the ICSID Convention on its own would not be a valid ground for withdrawing. And the footnote reference is a little difficult to read.
It's the Benevuti and Enfant case in the Cour d'Appel de Paris.
Yes. You can see the reference to Article 55, Lord, is the footnote reference 119 at the end of, however, it also reserves the validity of state immunity in the contracting states. Footnote 119, if you look down 119, Article 55, immunity from execution. And it's abundantly clear on a fair reading of the whole of that article that what Professor Shaw is talking about, again, is immunity from execution. While we're in this bundle, can I just pick up one other point? My learned friend referred to Professor Yang's book on state immunity and said that is where you get the specificity needed. And he didn't take you to it, he referred you to 4110 and 4111. All I will say about it, when you look at that,
49.
4110 and 4111 and behind tab 133 of this same bundle. And it's
I'm really sorry, 4110.
4110.
Yeah.
Professor Yang is describing the UK practice And my learned friend relies on that, and he relies on the fact that the English courts say you need to have, so and it gives an example you can see on which Professor Yang draws this conclusion in 4111, middle of the page. Thus, Argentina did not waive its immunity before the English courts by agreeing to submit to the jurisdiction of any New York State court or federal court sitting in the borough of Manhattan. 143 footnote.
Sorry, I've lost you.
It's perhaps, my lords,
Or-
I
did you
may
say
actually,
4110?
it's too, it will perhaps be too complicated to deal with this point at the time. The simple point is, Professor Yang's trying to interpret what he has seen as UK practice, but it's pre-NML in the Supreme Court. And he refers to NML in the Court of Appeal, which obviously came to the opposite conclusion from the Supreme Court on that point.
Yeah.
So it's just not a very good point. My Lord, on this fundamental question on Section 9, there's still this misunderstanding on the other side. My learned friends point out Article 25 of the ICSID Convention. It's quite right that the Article 25 is about the jurisdiction of the centre. But that doesn't alter anything. What we are concerned with is the question of who gets to decide the jurisdiction. Article 41 says it's the tribunal. Now, my learned friend's riposte to that today in argument is it's no different from the LCIA rules or the ICC rules, which also say competence is in the tribunal. But that is precisely why there is a difference. Because in an LCIA or ICC arbitration, you don't have either party being a member of the ICC rules. The ICC rules aren't a convention, they're not a statute, and neither of the parties is a party to those rules. The only way those rules come to apply is because they are in an arbitration agreement.
Yeah.
That's the fundamental difference that we are identifying with the ICSID Convention. And that's why, my lords, and again, I can't emphasize this enough, when you see the references under issue estoppel and the authorities to a standalone agreement to submit a question of jurisdiction to the tribunal, that's why we say the ICSID Convention, and Zimbabwe does not deny it's a member of the ICSID Convention, a party to it, it's ratified it, and the BIT, which it doesn't deny. When you take those together, that is the separate standalone agreement that the ICSID Tribunal gets to determine jurisdiction and gets to do so finally. So that's why we say that that's just a fundamentally different point from commercial arbitration.
But that's no, but they accept that therefore they cannot challenge jurisdiction in the way that you would normally challenge jurisdiction. But they say that Section 9 is different.
Well, no, because the point is, it's not, you can't challenge jurisdiction under Section 67 because it's not an English-seated
No,
arbitration.
so that's why you have the 1966 Act and the regime put in place to automatically recognise an award.
Yes.
But they say it's a different question when you come to look at state immunity. You then have to go back to satisfy the statutory test of whether there's an agreement.
But that's precisely why it's important that you have this standalone submission, because what the Section 9 question is not about whether the standalone submission is valid and binding, it's the underlying question. But you can't go there because you have. So what we try to explain is that English law permits it permits somebody to submit finally to an arbitral tribunal the question of the arbitral tribunal's jurisdiction. And that's what ICSID member states do. And that being the case, it's not that we are saying you rely, that's why I emphasised this point earlier, we're not saying you rely on the tribunal's determination per se. What we're saying is you rely on the fact that Zimbabwe agreed under the ICSID convention, there's a standalone submission that the tribunal gets to decide that. So it's almost like, as I described it initially, conclusive evidence clause. So we're not saying you don't look at section 9, you don't deal with it, but just that it is satisfied because of that standalone agreement by the tribunal's determination. Alternatively, it's an issue estoppel for the reasons we explained.
But isn't the problem with this is that whereas the question of the jurisdiction of the tribunal may be a matter for the tribunal, and the award is conclusive in that regard, Section 9 of the Act is directed to the court. Court must be satisfied, must it not?
Yes, the court must.
That it has agreed in writing, and can that statutory obligation be disapplied so that where in fact it has not agreed in writing, and that might ultimately be determined to be the case, the court is nevertheless bound to find that it has.
Well, my lord, the point, that's why I've tried to explain, what we're saying is not that it's disapplied. What section 9 does is it says you have to satisfy yourself. If section 9 is raised as the exception, that there was an agreement to arbitration.
What I'm saying is the court effectively has to regard that decision as having been predetermined by a body who, on the face of it, itself did not have jurisdiction.
What? No. What?
Let's assume a situation in which there wasn't an agreement in writing, but the ICSID tribunal wrongly determined that there was.
Yes.
So what we're saying is that the English court would be bound to find that there was an agreement in writing, which there wasn't, because the ICSID tribunal, which had wrongly assumed jurisdiction, had determined there was enough.
Yes, that's correct.
Well, that's a very far-reaching submission.
Well, my lord, it isn't. In fact, just take it in stages. As I showed you earlier, albeit briefly, in the recent Hulley decision, Mrs. Justice Cockrell expressly found that the court doesn't need to have a separate independent analysis of jurisdiction for Section 9 purposes in every case, and that Section 9 can be satisfied by an issue estoppel from, in that case, a foreign court. So it can be established without any detailed analysis by the English court. So that's a question of how you prove it. But the point, my lord, is, taking my lord's point on, if the Section 9 argument doesn't apply any differently from anything else, if it's accepted as it is by my learned friends now, that they can't challenge the substantive aspect of the award, including jurisdiction. Mikula tells us that. You can't go behind the tribunal's determination of jurisdiction. They accept they can't do that. But what they're telling you is, in Section 9, it's a free-for-all. They can go right behind it. So in your example, my lord, where the ICSID tribunal has wrongly, they think, has come to the wrong conclusion on jurisdiction, if there's no Section 9 point taken, this court recognises and enforces the award.
Well, except the court will be obliged to take it of its own merit motion.
Yes, but the court's obliged to consider the question of whether the state is immune, correct? But the court is not then looking behind the tribunal's award, rehearing jurisdiction of its own motion, because this isn't a question about whether there's a piece of paper with a signature on it. These are questions of whether particular types of activity might be said to constitute an investment. They're questions of judgment, and factual questions as well, but not simply, is there a piece of paper or something so high level that the court would be able to satisfy itself of. easily. So the fact is, what Malone friends are saying is, yes, okay, we've agreed to a regime where we can't do this, but the UK legislation permits us to completely rehear jurisdiction. We can even argue new points. And that, I can quite see that in a New York Convention context, because there is no finality on jurisdiction. But that is not the case in ICSID, where you have this very clear Supreme Court held the English courts cannot reconsider jurisdiction of merits.
But the Supreme Court didn't decide that in relation to sovereign immunity.
No, it didn't, but it decided it's a question of the ICSID scheme. It's even more fundamental than sovereign immunity. It's the very nature of the convention obligations that have been undertaken both by Zimbabwe in this case, but also by the United Kingdom. And it's a rather curious submission, my lord, in my submission, a bold submission, that the United Kingdom, having undertaken obligations not to allow the review of ICSID awards, is being said to have passed legislation which expressly, it is said, requires the court to conduct just that review. Just checking if there are any other points. No, my lord, I think I can conclude on that, subject to any other questions that my lords have, of course.
Thank you, Mr. Harris.
Very grateful, my lord. I don't know whether Mr. Green or Mr. Balloch wants to.
My lord, Mr. Balloch has very graciously offered me his time, or rather offered Mr. Moulan his time to accommodate the extra time, I think.
Look, I may have something to say.
Oh, but he said he may have something to say.
Depending on what you say.
Probably. Yeah. I shall try and be reasonably brief, my lords, particularly given the hour, but there are a couple of quite important points. If we can take 1 second to step back, the sovereign parties invite this court to make a decision which will put the United Kingdom in breach of its international obligations under the ICSID Treaty. So that's the premise. In two respects, they invite the court not to enforce, in fact, recognise and enforce the award under Article 54, and they invite the court to find that Parliament failed effectively to comply with the international obligation under Article 69 to put in place effective legislation domestically to comply with Article 54. And we respectfully say that the basis of, as well as making the United Kingdom an outlier in convention countries about the correct approach under the convention, we say the basis upon which that is urged upon the court is not a satisfactory basis to justify taking that course. To be fair to Mr. Justice Fraser, there is a simple analysis by which his short route may be reached, and that is simply this. At a simplistic level, if the sovereign states are right, they get to set aside the award, and the United Kingdom is then in breach of its international obligations under the treaty. And in Micula, at paragraph 68, the Supreme Court held that the provisions of the 1966 Act must be interpreted in the context of the ICSID Convention, and it should be presumed that Parliament, in enacting that legislation, intended that it should conform to the United Kingdom's treaty obligations. That binding precedent on Mr. Justice Fraser precludes the decision which the court is invited to make. So that was a legitimate course of reasoning by Mr. Justice Fraser to say, if we do this, it's common ground the UK will be in breach on the international plane. Supreme Court in Micula has said, no, that's not how the Act should be construed, so I'm going to construe it so that doesn't happen. And that is actually our old friend ground one, or a supporter of our old friend Ground One in that regard. So my learned friend had a point on section 4 of the Act. Could I just ask the court to look at that? Because I've got 2 points on the Act, and I'll do them together.
4 of the
1966 Act. That's found on page 24.
Yeah.
And I won't take the court to Hansard, but you'll see the background to that there as well. The concern in Hansard was conferring new immunities. There was objection and concern in Parliament about conferring new immunities. And the point on section 4 is it's not about whether immunities are taken away, it's about whether new immunities are conferred on the centre and so forth. It's got nothing to do with the sovereign immunity issue that's before this court, point 1. Point 2 is the fact that the particular parts, articles of the convention are directly given effect by section 4 says nothing about giving effect to section 54 at all, because that's done through the actual express provisions in the Act.
Article 54.
What did I say? Article 54.
Yeah.
Article 54, and that the scheme of the convention, including 41, 53 to 55, 50 to 52, and 69, are all given effect by the actual working parts of the Act. And it's very important for the court not to lose sight of what section 2 of the 66 Act tells us the effect of registration is. And we see that on page 23, which is subject to the provisions of this Act, an award registered under section 1. So the court receives an authentic copy and Parliament says you've got no choice but to register it. That's it. It doesn't say if you feel like it or if there's a sovereign immunity point, don't, or anything. Direct obligation. And then section 2 says, subject to provisions of the Act, an award registered under section 1 above shall, as respect to pecuniary obligations which it imposes, be of the same force and effect for the purposes of execution as if it had been a judgment of the High Court, given when the award was rendered pursuant to the convention, entered on the date, etc. And so far as relates to pecuniary obligations, proceedings may be taken, some may be registered, will carry interest, and the High Court shall have the same control over the execution of the award as if the award had been a judgment of the High Court. So that's unequivocal in showing the follow-through from the consequence of registration to the exercise of practical jurisdiction of the High Court, subject always to the common law immunities, restrictive immunity against state assets. So that's the effect of that. Second point was made rather well by my learned friend. I was looking forward to doing the footnote point, but the footnote in the Schroyer himself argument, my learned friend took the court to the footnote, and the footnote goes to Article 55, which is immunity for execution. The reason, the way I was going to tee it up was just to point out that in Schroyer's own commentary, he says the opposite, and the court will find that, I won't take the court to it, but you'll find that at volume 8, 146, 4342, and he says, Mr. Broche explained the very point my learned friend was trying to make, but as to execution immunity only. And there's an excellent point, just to add to my learned friend's point on the Travaux, quickly, if we may, bundle 9 at 155. Sorry, apologies. It's, let me just check. I've got 2 references. I do apologise. It is, yes, there's 2. We'll do bundle 9, 155, 4575 first, if we may. They won't take a second, but they are worth a quick look. Because they strongly fortify the point that learned friend was making.
Yeah, got that.
So 155, and does the court see in the paragraph with the top red sidebar, he pointed out,
Sorry, which
Yes.
one?
4575.
4575, he pointed out the draft convention not establish any mechanism for enforcing awards, etc. And then you'll see section 15 in the middle, 5 lines down, and then members of the European Economic Community have renounced certain of their sovereign rights and accepted decisions as binding in the same way as was being attempted by the present convention. He did not think that the alternative proposal put forward by Germany, etc. So it's absolutely clear, and the other reference is in the other bit of the Travaux, because they came in $2. In volume 7, if we can go quickly to that, it's in 118. And it's at 3783.
Yeah.
And oh, sorry, that's a misreference. I'm sorry. Apologies. I do apologize. Let me just get the correct one. I'm very sorry. That is actually. I apologise. There's another one. I've got the wrong reference. But the court's got the correct reference for the first one, which makes it absolutely clear. So that's that dealt with. There's a couple of other points, if I may. There's a very important point on this implied waiver business. Court's got our primary case. The words are completely clear, and there's nothing implied about it. You just read them and get their meaning. But it is useful to understand that between Chief Justice Alsop's judgment in the full court of the Federal Court and the High Court of Australia's judgment, there's a judgment of the well-respected Justice Cook in Sodexo, which we've got in the bundle in volume 6.
New Zealand judge.
New Zealand judge, exactly. And there's one key point. Can I just take, I appreciate I'm asking the court to zip around the bundles. It's volume 6. It's tab 85. And if we can just look at 3008 first.
Yeah.
So it's Sodexo against Hungary. It's an ICSID award, as we can see from page 3000. The relevant familiar set articles are set out. And then if we go to 3008, you can see at paragraph 28, Mr. Justice Cook says, I do not agree with the analysis of the BVI High Court in Tethian and so forth. And he considers the correct interpretation of the scheme and recognised concepts of state immunity. And then if we go to 310, he refers to the decision at the top of 310, the analysis, the overall summary of Alsop CJ in the Kingdom of Spain against, in this case, basically in Australia, in the full court of the Federal Court, and finds that Hungary is not able to claim state immunity. There's a key useful point, if I may, on 3014 in footnote 45, which I invite the court to find as an excellent observation in relation to this exercise of understanding what's expressed and implied. Footnote 45, ascertaining the true meaning of an express term by reference to the necessary implications of other terms is conceptually different from implying a term. And my lords, you don't imply a term, but you do this, and when you do that, you still get exactly the answer that we've given the court. So it's rather an elegant formulation of that distinction, which is maybe quite helpful. And then I think, almost finally, the learned friend, Mr. Moulan, suggested that there was no intention to make the ICSID treaty pro-investor. All I would say is what's absolutely clear from everything is it was pro-effectiveness of encouraging capital flows by giving proper protection.
Yeah.
That was the whole purpose of the treaty. On my last run-in, if we could quickly go to the consent in writing point raised in the 66 Act itself, in the convention scheduled to the Act. There are a couple of quick points for the court to have in mind in relation to the consent in writing point. Article 25 was referred to, which we find it starts on page 33, and the court was invited to consider that. It's right that the court should have in mind that Article 26 provides consent of the parties to arbitration under this convention shall, unless otherwise stated, be deemed consent to such arbitration to the exclusion of any other remedy. Does the court have that second line?
Yeah.
The contracting state may require the exhaustion of local administrative judicial remedies as a condition of its consent. So that's why the European Commission, just parenthetically, had that letter, the Annex 1D letter, to say people could still go to the ECJ if they wanted to. But that's part of the scheme, and the court should know that in Chapter 4 on page 37, just to see quickly how it works, I'm sorry to go at pace, the court will see the provisions of Article 36. It's quite important to have it in mind. A contracting state or any national wishing to institute arbitration proceedings shall address the request of the party in writing to the Secretary General. So it has to be in writing, the request, and that's the written acceptance of the state's unconditional offer. And then contains the information, identity, and their consent in accordance with the rules of procedure, etc. And then this is the first filter that was agreed by the contracting states. The Secretary General shall register the request unless he finds, on the basis of the information contained, the dispute is manifestly outside the jurisdiction of the centre. So there are three filters. It's right, the court should know. There's 36.3, then there's the so it never gets to the tribunal. Then if it gets through that filter, then the tribunal under 41 has exclusive jurisdiction to make the decision on the jurisdiction, not because of 41 alone, but because of the combination of 41 and 53 and 54.
Yeah.
So that's why they can't go behind it, even on the Section 9 argument, which I'll briefly mention. And that is in also Malone and Friends' analysis, and Harris's King's Counsel's excellent analysis. It's also totally consistent with the absence of the curial seat. That's a very unusual feature of ICSID arbitrations, the absence of curial seat. There is no individual country which has control and can upset jurisdiction. And that's entirely consistent with the provision that the ICSID tribunal shall be the only judge, with, of course, the ad hoc committee as a third tier, the only judge of its jurisdiction.
Yeah.
So that's that last point. I'm almost there, my lords, I promise. The final point is just in relation to two tiny points. It's not actually correct for Mr. Moulan to talk about submission by the contracting state before the United Kingdom exercises jurisdiction, because the specific provisions in this jurisdiction for the ICSID Convention require normally an ex parte procedure. So there's no submission in the face of the court before the court, in accordance with the rules, normally exercises its adjudicative jurisdiction. That's only consistent with our argument, we respectfully say. And finally, just in relation to the question of Section 9, which Malone and Friend was addressing, how that fits in, I adopt what Malone and Friend says, but my lords, it does vaguely suggest that actually, on analysis, although you can call the SIA a complete code, because it doesn't, everything that the 66 Act does fits at least within it, certainly on Section 2, and we say, on effectively a statutory deeming of there having been an arbitration agreement for the purposes of Section 9, either analysis of those analysis that my Lord Justice Phillips put to me works. Either it's a freestanding one, or to which the SIA has done no violence, and one just harmoniously interprets two related statutes, or whatever happens under the 66 Act, it falls either under Section 2 or Section 9, or both. But for all those reasons, my lords, we respectfully say that the court should not make a decision in this case which puts the United Kingdom in breach of its international treaty obligations, for the reasons set out in the Supreme Court's judgment in Mekina. That's it. Yeah, unless I can help. Is that the one? Mr. Barr.
My lords, 90 seconds is all I need. You have heard some excellent advocacy, and I hope you won't at least forget my contributions. I won't call them excellent.
couldn't forget.
But can I just remind the court, because as the questions have come, I spoke about the way in which jurisdiction and immunity questions are navigated. They are preliminary questions. And when you look at those decisions, which are from paragraph 13 onwards, you'll see how the language of defences in the ICSID Convention should marry up to that. But next stage, the preliminary question, that's not about the merits, which the Supreme Court keeps telling us. So that's how they match up. And my lord, just a second point on that Schroer quote.
Yeah.
If you can go to it, and I can just explain to you why it must be talking about.
So which one is it?
That's the volume 8, page 1, tab 123, page 3927. My lord, it was said that this was only talking about execution immunity, but that cannot be right, because Professor Schroer says that the way to waive it is via an arbitration. You can't waive execution immunity via an arbitration. That would really worry us. So let's just be clear that that can only be talking about adjudicative jurisdiction. And that's obviously quite apart from the many references and the way my learned friend Mr. Milan explained, and I tried as well, that really the aim was for these awards, if they're going to find their way through immunity, it's Section 9. Well, that's what I wanted to say, unless you had any further questions.
Thank you all very much indeed. I hope everybody feels that they've said everything they needed to say. Obviously, we're going to reserve our judgment. That would surprise you, wouldn't it? Realistically, I think you will be extremely unlikely to get a judgment this side of the summer vacation. It's just not. It's a major case, or two major cases. Requires a lot of thought, a lot of consideration by all of us, really, between ourselves. So please don't assume you'll get something by the end of July, because you simply won't. When you do get it in draft, it's only for the purposes of typographical and similar errors. It's not for inviting the court to reconsider arguments that have been raised and so forth. And the only other thing I'd say is please pay attention to the terms of the embargo on the draft judgment and ensure that it's complied with, and only those people who are supposed to have access to the draft for the purposes of deciding which the typographical errors are, have access. I mean, obviously there are circumstances in which, if you need to disclose the judgment to your respective clients, I'm thinking particularly of the sovereign clients, and there are people within say the Ministry of Justice of the respective countries who need to be informed, then what you'll need to do is, through my clerk, to let me know who else you want to show the draft judgment to, and we'll obviously consider that. Subject to that, the only other thing I would say is to thank you all very much indeed for the way in which these two appeals have been presented, with at the end of the day, I think good humour all round. And I'm also we are very conscious that although we've heard now from 5 counsel that the work that goes into the submissions and what's said by the 5 counsel who are the mouthpiece is work to which everybody has contributed, both the other barristers and the solicitors as well. So thank you all very much indeed.
Court riseth able.